Number 24, Nemeth versus Brenntag, North America. Counsel?
Good afternoon, Your Honors. Bryce Friedman, Simpson, Thatcher, and Bartlett for Whitaker, Clark, and Daniels. I'd like to reserve 2 minutes for rebuttal, if I may.
You may, sir.
The primary basis for setting aside the verdict is that plaintiff failed to show as a matter of law that Mrs. Nemeth was exposed to a sufficient amount of asbestos in desert flower dusting powder to have caused her peritoneal mesothelioma. At trial, plaintiff did not present expert evidence specifying the level of exposure to respirable asbestos that would have been sufficient to cause her peritoneal mesothelioma, the specific cancer with which she was afflicted. Plaintiff failed to provide the fact finder with a scientific expression of the exposure level known to cause peritoneal mesothelioma, and that Mrs. Nemeth exceeded that level. And I want to make another point, which is very relevant to all of us as we sit here in masks for the last 2 years, that there was no evidence of the amount of asbestos plaintiff actually inhaled or breathed in a space with the dimensions and air conditions of her bathroom, given the specific record of her use.
Counsel, if I can interrupt, I'm on the screen. Hello, good afternoon.
Good afternoon.
On this last point, is that required? Is it required to show what the person actually inhaled?
Well, exposure is required, but there's a lot of shorthand in these cases that leads to unfortunate results. Because exposure in this case means inhaled, and that's why we have the second issue with respect to the problems at summation. Just because somebody was exposed to something doesn't mean it had a potential to cause disease, and there's no dispute in this case that the only exposure is the potential to cause disease is if the toxin got in her lungs. So yes, she had to be in a condition in which the toxin got in her lungs. It's sort of trite by now, but we all know.
Okay, but wasn't there an expert who did, of course, the glove box test, but who also did measure sort of some of the inhalation rates? It is a releasability, right? That's sort of the asbestos releasability is the main part of that test. But there's more to that test, is there not?
There is not. There is no expert who testified anything, not a single word in the entire case about inhalation. What the expert did, it took a box about this big, put the product in the box, shook it up, and measured whether any asbestos was released from the product, and said what was released was orders of magnitude more than is in the ambient air. That is it. There is no discussion of what she may have been inhaling or otherwise. And in fact, most of the cases that have come before the court.
Well, if you're in a bathroom and you're using this powder all over your body, and then you're cleaning it up, which is, I recall it, you're not disputing that part of the evidence. Some of it is going to be inhaled. I'm not saying you're not correct that the law requires that we don't go around saying, well, just because it's in the air, we assume you breathed it. I'm not saying otherwise. But it's not true that there's no evidence, right? It's just you're saying, look, it just doesn't reach enough of a threshold for the jury to have come to a conclusion in favor of the plaintiff on that issue.
I'm saying more than that. Not only was there no evidence of how much she inhaled, I understand a jury could have found that she inhaled some of the powder that was in her bathroom. That is not an unreasonable inference, but there is no evidence of how much she inhaled, and most importantly, that even if you make wild assumptions that are not in the record about how much she inhaled, how much could have caused, and this is important, not just mesothelioma, because when you read the record, all the testimonies about mesothelioma, it is peritoneal mesothelioma, which is different than the plural or...
Well, I'm sorry, counsel, is there doubt in the evidence that asbestos causes the kind of cancer that the decedent suffered?
There is doubt in the evidence that the level of potential exposure she has does, but in the abstract is...
Okay, so that's a little bit different. That's your first point. I'm not challenging in terms of you making that point, but I just want to be clear that you're not here today suggesting that asbestos doesn't raise the risk of getting the cancer from which she suffered. You're
There
just
is
saying there's
evidence-
not, they didn't connect the dots. That's your point.
There is evidence in the record on the point that Your Honor just asked about, which is there is a level of risk raised. But this is important, and if you look at one thing in the record, look at the famous Helsinki criteria, which is 897 in the record, which is a report of a gathering of some scientists in Helsinki, Finland, at which they identified ways in which you could attribute exposure to asbestos-related disease. And this is the primary source of scientific evidence that's in the case. And what it says is you can take exposure history and to attribute a disease to asbestos, specifically pleural mesothelioma. But if you want to go to what we have here, peritoneal mesothelioma, it has to be higher levels of exposure. But nothing is defined. So when this expert in this case just talks about, oh, there could be a
So
relationship.
counsel, why doesn't, if you've got one expert saying, you know, you go in the box, here's a certain level of magnitude of the asbestos that's released, that might be breathed, and you've got another expert that says, look, all the data shows that there are these standards that the federal government uses. This is very high above those standards. Why isn't your argument an argument about the weight of the evidence, that the jury can decide, you know, given what we've heard on direct, given what we've heard on cross, we're going to hold in favor of the plaintiff, or if they could have held in favor of the defendant, I assume is your position. Well, why doesn't that go to the weight as opposed to whether or not that satisfies the minimum standard necessary to get this to the jury?
Because the evidence you just described is not, in fact, in the record. Because let me give you one specific example of what you just said. You said federal standards are exceeded. Well, there are federal standards that says we can all work in this courtroom based on a measurement of what's in the ambient air, and if the level exceeds that, it's not safe to work in the courtroom. Well, guess what? Those measurements are not in the record at all with respect to anything that happened in this case. So the fact that there exists a standard and the fact that the plaintiff didn't put any evidence of the standard forms the
Well,
basis
I
of
thought
our
that you
argument.
said that the expert who uses the box says it's the amount that's higher than the ambient air, and that's also Dr. Moline's, she relies on that and says the same. Again, you might say, you know, that it's just not good evidence. It's not strong enough. But I'm not sure you're correct when you say there's no evidence. It sounds to me like you're arguing again over the quality of this evidence, which is to me different from whether or not it meets the minimum threshold.
No, respectfully, I think I'm not arguing about quality at all. I think I'm saying there is no evidence sufficient to bring this case to a jury. Just the fact that there is more of X than it is in the ambient air doesn't tell us anything at all. I want to address something that I think is behind some of the questions and is an important point that is raised in the dissent, in the majority opinion in the First Department, which is somehow that us asking the court to specifically apply the Parker standard and saying that there is no exception for asbestos cases somehow means the death knell of asbestos cases, and that is absolutely 100% not the case, and the record here shows you that. There were 9 other defendants in this case who paid over $1 million to this defendant because the proof against them and their actually asbestos-containing products met the Parker standard, and that's why they paid the money. But here we're in a line-drawing exercise. This is not a product that was designed to be created with asbestos, and if there is no actual evidence that this product's exposure to this product causes disease at a certain level of exposure, there has to be the line that's drawn, and that's the Parker line. And we're just asking the court to apply it to an asbestos case in this case. And I see my time is up, so I'd like to just reserve the 2 minutes, please.
You have your 2 minutes, sir. Counsel?
Thank you, Your Honor. May it please the court, Seth Diamond for the plaintiff respondent. With all due respect, the arguments that were just presented are either completely out of touch with Parker or boil down to mere semantics. So take, for instance, the assertion that we have to show the exact level at which Mrs. Nemeth actually inhaled the asbestos fibers.
So even if You are correct that there's no exact level. What measurement, if any, was shown?
The measurement was quantified as more than 2 million asbestos fibers, amphibole asbestos fibers, the more potent type.
Well, that number's the glove test, the glove box test. The discussion we were having was about inhaling it. Is there any number on inhalation?
Your Honor, that is the inhalation number, and let me explain to you in the record why. The discussion about releasability is not related to this test on desert flower. It's related to a different test discussed in the peer-reviewed literature. That is borne out in the record on page 3177 through 3180. It's a different test. For this test, our testing expert said on page 3187 of the record, the purpose of this test is to target the actual exposure. That's why we're putting filters in the breathing zone. That's why we're using respiratory rates with the pumps that we have in the glove box. And then the mathematical modeling, one of the actual methodologies identified by this court in Parker, was then used to say, here's what the actual exposure is. And two other critical citations, 3219, where our expert says, yes, if it's getting in the breathing zone, it's being inhaled, and 4818, where our medical expert says the exact same thing. And indeed, think about this. The idea of having a breathing zone is because that's the zone of air you are breathing in. So the asbestos being released into that breathing zone is being inhaled, which Ms. Nemeth did on a daily basis in her cramped, unventilated bathroom for 11 straight years. And
Counsel, if I can interrupt you, I'm on the screen. With respect to what you're arguing now, I just want to be clear. Are you saying that the experts relied on studies to that effect? That is to say that studies say if it's in the quote-unquote breathing zone, then obviously it's inhaled, it's going into your lungs, or is that a conclusion they drew from their experience or from something else? I just want to be clear on what you say the record represents.
the answer is both, Justice Rivera, and let me give you a few other record citations on this. On page 4108, Dr. Merlin says, when you use a cosmetic talc product and it's generating levels at orders of magnitude above ambient background level, multiple studies show that at that exposure level, you will see elevated rates of mesothelioma. And keep in mind that this is a causation record.
So was the doctor's testimony at that point tantamount to saying anything above the level of asbestos in ambient air is going to be causative of peritoneal mesothelioma? Was that what she was saying?
No, there's another point where she is defining what it means to have a non-trivial exposure. And that's an instance where she says a non-trivial exposure that's going to contribute, not that's going to be a substantial contributing factor, but that's going to contribute is one that is double the background rate in the ambient air. So compare that to orders of magnitude higher, 2.7 million asbestos fibers. The more carcinogenic type of asbestos is 2 orders of magnitude greater than the 60,000 in the ambient air. Pages 3942 through 3945 make that out. And so,
Counselor, aren't those just association studies and association evidence versus cause and effect?
no. And what you're referring to, Justice Angus, I believe, is the Welsh study. That's one piece of the evidence. But the Welsh study found a 6-fold increase for peritoneal mesothelioma, including in non-occupational settings. 6-fold increase is well above a association. 2-fold increase is causative. But there's other citations in the record, including page 4400 through 4402, where Dr. Milling specifically says, here's an exposure level which we know is thousands of times excess risk. And she's asked, tell me the studies you're relying on that this level causes peritoneal mesothelioma. And she says, let me tell you, there's 5, 2 from Authors LaCourte, 1 from Rodersberger, 1 from Iwatsubu, and 1 from Agudo. And there's 0 cross-examination whatsoever on any of that predicate. So that goes to CPLR 4515, which says once we've laid bare our scientific predicate, it's incumbent upon the defendant on cross-examination to delve into that data and try and knock down some of those articles. It wasn't done. So that's more of a weight of the evidence challenge than legal sufficiency. And consider that not a single case-specific opinion was offered during this trial by any of the defendant's experts. So all of this scientific proof came in completely unrebutted. And so I think when you really look at this and the idea that under the standard of review, valid lines of reasoning and permissible inferences, it simply cannot be said that this is an instance that was utterly irrational for the jury to have reached the causation finding that it did. And I think it's somewhat fortuitous that this court recently decided the Juni case, because we can look at those two records and we can see stark distinctions across every element of causation, but the most critical of which is the idea that in that case, the product was radically altered such that the asbestos converted to a non-toxic substance, and you can't apply the conventional asbestos toxicology to that product because we don't even know necessarily if it's an asbestos product at that point. Compare that to here. There's not even an allegation, let alone evidence, that the asbestos taken out of the earth, put into this appellant's talc, changed form, chemical composition in any way when Mrs. Nemeth inhaled it. And when we consider the idea that these are completely different records, it makes sense why the appellate division fell on the opposite side of the coin, the legal sufficiency coin, from the Juni case. And there's an inherent contradiction in the appellant's argument on this issue. You look at footnote 8 of their opening brief. They cite cases in which they say, oh no, those cases, causation was validly established. And those were not cases where actual inhalation was demonstrated, because a lot of times, in the vast majority of times, we don't have the ability to do quantification evidence. We have the ability to test the product here. We're not going to get that in the vast majority of instances. So when we go back to Parker and we see that, look,
So was her exposure quantified in any way here?
it was quantified by the glove box test, which then, via mathematical modeling, said the exposure was 2.7 million fibers in the breathing zone. And you link that up with the testimony that this is being inhaled because it's in the breathing zone, and we have an actual quantification of exposure. And also keep in mind, there's no other evidence on this record of asbestos exposure from any other product. There's no other risk factor for peritoneal mesothelioma on this record at all. All we have...
Counsel, Counsel, if I may ask you a question, I don't know that you'll be able to answer it, and I would understand why. There is an amicus from Colgate. I don't know if you are familiar with what the amicus raises, but they have an exhibit which references, in favor of Colgate, an expert's modeling, and I was wondering if you knew what that modeling was and if it was in any way similar to the modeling used by the expert from your client.
Yeah, Your Honor, I think that was an attempt at precise dose quantification in there, and that was something defendant attempted here. It was precluded as junk science, and there's no challenge at this point in the appeal as to the preclusion of that junk science, which simply says it's not something we in science are really capable of demonstrating. And go back to Parker for a moment. The legal framework in Parker is tied to the science because Parker was trying to strike this balance. We don't want highly credentialed experts coming in and saying, here's a conclusory opinion, but we also don't want to generate an insurmountable burden for a plaintiff. And so what we did here, by actually testing the product at issue, was provide more evidence than what has already been deemed to satisfy the Parker standard, and that for those reasons, this is an order that should be affirmed. Thank you.
Thank you, counsel. Counsel, your rebuttal?
Counsel, before you start, could you address what you want to address, but could you address the releasability versus breathability of the glove box test?
Sure. I think that I was going to begin by referring the panel to the record because my colleague made a lot of references to the record, but I may not necessarily disagree with, but I don't think going through that in my 2 minutes is a useful part of the time, but I will refer the panel to 2019 where Mr. Fitzgerald offers his releasability opinion, and 3180, which he's asked why he did a releasability study. 3199 where he says what he found, and 3200 where he gives this 2.7 million number, which sounds very impressive, but so what? I mean, it could have been 5 million or 25,000 or 86 million. It doesn't really tell us anything. It tells us nothing about whether that's good, bad, otherwise, or relates to peritoneal
But
mesothelioma.
counsel, the argument is that the glove box test has a breathing component to it as well.
Right, so could you address that?
There is no breathing component to it. I read Mr. Fitzgerald's testimony again yesterday. There is no breathing component to the test. The closest thing to a breathing component is the sensors were put in a bunch of different places in the box, and that's it. There's nobody breathing in. There's no statement that this is the amount of asbestos that.
But again, counsel, isn't that about you disagree with sort of whether or not it's persuasive? It's not that there's nothing there, right? You just said that there is some machinery there, but you're disagreeing as to whether or not that should be persuasive. And given the standard on our review of the fact that there was a jury verdict for the plaintiff, again, isn't the opponent correct, your opposing counsel, that that's to the weight?
Not even, I disagree, not even the experts in the case said she breathed in 2.7 million asbestos fibers. That was just a statement of what was in the
Yes,
box.
but I asked you at the beginning, is that what you need? Do you need someone to say, look, this is exactly what she breathed in, and you yourself, and you can correct me if I'm wrong, conceded that's not necessarily what you need? And I agree with you, you need something. And no one's saying you don't need anything. Our case law is very clear, you've got to have something.
We're in agreement you have to have something, but more than a measurement of asbestos released into the air.
Okay, so let me ask you this.
Yes.
If we disagree with you and decide that the record does indeed present evidence on breathability, do you lose?
No.
Why not?
No, because what this court said in Parker is that plaintiff had, quote, far more exposure to benzene than did the refinery workers in the epidemiological studies. The court found that plainly insufficient to establish causation. It neither states the level of the refinery workers' exposure nor specifies how Parker's exposures exceeded it, thus lacking in evidence to support the claim. Even if I assume you're correct, Judge Rivera, and that's in the record, you still fail that test under Parker. There is no question about it. My colleagues on the other side haven't even argued otherwise. Thank you, Your Honors.
Thank you, counsel.